So my name's Chris Thompson. I'm the Executive Director here at Generator, and I'm thrilled to welcome you all again to Jumpstart, our latest iteration. I've got a couple announcements to make because there are some very cool things happening. First off, I hear from John Antonucci from LaunchVT that there are 2 teams from LaunchVT Collegiate here. Can you put your hands up? Let's see. There you go, and congratulations. You guys were the winners, right? And you guys are working with us over here on another. Very cool. Excellent. So that's actually one of the things that I'm most excited about this program is that this program is designed to interface directly with LaunchVT. In fact, John Antonucci created the curriculum for this, and he's done an amazing job for that. And so I also want to make sure you guys know that actually the applications for LaunchVT are open now. And this program was all designed to feed right into that. So by the time you're done with this, and our cohort has been working on their prototypes, that you should be ready for that application. So I suggest you go online. It's an incredible program to take advantage of. A couple other things are coming up. We have a new speaker series next week that starts called Reckless Ideas. And the idea is that we're bringing together people who have sort of kind of radical ways of looking at the world, interdisciplinary work, and they're coming from all over the place. It's done in collaboration with the Complex Systems Group up at UVM. And our first speaker is going to be Josh Bongard, he's actually going to be speaking about autonomous yet safe robots. And of course, like everything else, it's going to be fueled with a little bit of beer and food. So definitely come on down for that. It's going to be a great speaker series, lots of really interesting people. And the idea is to sort of get people together and thinking about different collaborations and working together as well as listening to the speakers. Final thing before we start moving on this is we're going to be doing another iteration of something we call Pitch It, Fab It. And Pitch It, Fab It is a collaboration with UVM's Instrumentation and Modeling Facility. And what they do, it's a pitch program where if you've got a prototype, particularly if you've got a prototype that might have some aspect of it that we don't have the exact tooling here for you to be able to do, they have the same prototyping facility they've got that they have been doing medical instrumentation. They've been doing incredibly detailed, hardcore prototyping up there. They're going to open it up to you, and the winner gets $5,000 worth of prototyping work with the specialists and the experts up there and their incredible facility. It's a really good opportunity, and there are going to be instructions online. Come to our website and take a look, but it's a pitch, it's a really fun thing because it's an evening where a bunch of people pitch, and you pitch with slides, and you have a couple minutes each, and it's very cool. And that's going to be, that pitch is going to happen on April 18th, and the application process is going to be about a month before that. So watch out on the website. One more thing, definitely if you haven't signed in, sign in, because everybody who attends a Jumpstart event here is going to be, we're going to be emailing different special discounts on classes and things here at Generator. So definitely take advantage of it. So I'd like to now introduce David Estes from People's United Bank to say hello. There's David. So, by the way, People's United Bank has been incredibly gracious and supporting the program here, and I just really want to thank you once again. It's been amazing.
You're welcome. Thanks. So I'm Dave Estes. I'm a commercial lender at People's United Bank. So typically my day-to-day responsibilities are a lot larger loans and big companies. And so I got to tell you, I get really jealous and really feel like I'm missing something when I'm around a lot of entrepreneurs, because I think this is a whole lot more fun than kind of what I might do on a day-to-day basis. But I was just talking to Karen and Brian in the back, and I was telling them that too many big companies have sold. And so we need the next generation of companies to come along. And so, on behalf of People's United Bank, just really proud to be a part of this. Really wish you all the best of luck, and hopefully at some point we'll be able to help you out at People's United Bank. So best of luck to all of you.
Thank you. So in addition to People's United Bank, we have a number of other incredibly gracious sponsors. We have Davidson Hodgkins Associates, we have Merit and Merit Lawyers for Growth Companies, we have Fresh Tracks Capital, Middlebury College, M&E Designs, Center for Women and Enterprise Vermont, and BTV Ignite and RETN, who are our media sponsor. Okay, so now, all that. So I'd like to introduce our speaker tonight. Justin McCabe is an intellectual property partner at the law firm of Dunkiel, Saunders, Elliott, Raubvogel, and Hand. Justin's law practice has a heavy focus on assisting startup ventures and entrepreneurs with patents, trademarks, copyrights, licenses, and agreements. And when he's not patenting inventions, he can usually be found building maple sap evaporators with his family's new startup, Vermont Evaporator Company, located in Montpelier, Vermont. But most importantly of all, Justin's one of the incredible board members here at Generator, who we really appreciate. So I'm going to turn it over, but apparently, so you guys were on Vermont. Do you mind talking a little bit about that before you get started?
Oh, absolutely. Yeah.
Thank you.
Yeah. Yeah. So I'll go into this a little bit more as the presentation goes on. But 4 years ago, I had a problem. I was making maple syrup, or trying to, and I had a pot and I had a grill, and I spent a lot of money on propane, and I got really crappy syrup. And I started looking around. I couldn't figure out how to solve this problem, and so I'm a tinkerer. I'm an engineer, and so I spent some time in my garage, and I came up with what I'll show you later is our flagship product, the seedling evaporator, or the sapling evaporator. And I sold a dozen on Craigslist to sort of recoup my funds. And what do you know, a company was born. And so now we have an employee in Montpelier, Vermont. We're going to sell 250 units this year. My wife is the CEO. And it's one of these small Vermont startups that we have a commercial lender in Montpelier that we use. So it can happen to you too. I'm going to show you a little bit of some of the steps and hopefully how to get you there. So my presentation is how will it compete, right? It's interesting that that's the title, because I think in a way how it will compete is not really what I'm going to talk about. I'm going to talk about how you can compete in this marketplace, how you can protect what you're building, right? How you can protect all the money and valuable time that you're putting into your new startup business, and you can protect that and create a little bit of space for you to thrive, right? That's what I want to give. I'm also going to talk about business formation. Again, this is about protecting your business and the assets that you've accumulated and separating that from your personal assets. The presentation is going to be very dense. There's a lot of IP to talk about, intellectual property. But please feel free to ask questions as we go along. I will try to save some questions for the end. I'm planning on this being about 40 minutes long. But this is going to be a little bit interactive as well. There's a little bit of a quiz in the middle. Don't freak out, right? And but please do ask questions if you have them along the way. All right. Just to give you a little bit of background about myself, I have a bachelor's in chemical engineering from the University of Michigan. I graduated in 1998. I was working for a while, and I went to night school and got my master's in chemical engineering from Case Western Reserve University. Then started working for a little while more, then decided to go get a JD. While I was doing that master's degree is actually where I came into my interest in intellectual property law, namely patent law. The ME program at Case is actually designed around product development. And as part of that program, we had a patent attorney come and talk to us and tell us how we could patent the inventions that we were working on as part of this class, much like I'm here today. So if anybody has any interest in the patent law field, we're actually running out of patent attorneys, if you can believe it. So as an alternative motive, you can talk to me about that as well. I am a partner, as Chris mentioned, at the firm of Dunkiel, Saunders, Elliott, Raubvogel, and Hand, which is located on College Street. And I am also the owner and chief engineer of the Vermont Evaporator Company, as Chris mentioned as well. So how will it compete? How will you compete? Note, you cannot eliminate all of your competition, right? That's not possible. You're not going to create this highway for your product to live on, right? That's just not going to be feasible. It's just too crowded. The field is already too crowded. We're almost up to 10 million issued patents, right? That doesn't even count the ones that didn't get issued. Only 25% get issued of the applications that are put in per year get allowed to become issued patents. So, we're talking, documents and documents, and all that becomes prior art. It certainly obstructs the sort of the clear lane that you may have for your business. But you can protect your investments and your ideas. You can create some space for your company to grow if you are strategic. You can build value in your company through protecting your intellectual property, protecting your trademarks, your copyrights, and your patentable technology. And you can reduce your risk by understanding what others are doing and not jumping in without checking first, right? We're going to talk about that today. How will you do that? You proactively and regularly evaluate your intangible business assets and taking steps to protect them. Seems like a mouthful. What does this mean? You take stock. Every once in a while, check in, right? Figure out, what have I done? Have I developed something new? Did my product materially change? Does this mean I need to reevaluate where my IP is, right? Did I start using a new mark? Did I publish something that could be useful to somebody else? There are things you need to do to check in that will assist you in making sure you're capturing those assets for your business. The takeaways for today, understanding of the principal intellectual property types, namely patents, trademarks, and copyrights. And then risk considerations. What are the risks to your business? What do you need to be thinking about? And the purposes and benefits of certain corporate structures. So what is intellectual property anyway? We talked about the three main categories. Those are listed here, right? We have patents, material objects, things we find, systems. We have trademarks. This is a local company from around here. They make cold brew coffee. Copyrights, which obviously includes commercials, right? Or even publicity rights. What else includes intellectual property? Well, trade secrets. Value to your business that's not generally known. Domain names are typically found in the auspices of intellectual property areas. And then the rights of publicity. Again, an intangible asset, potentially, depending on what your company does. We're only going to be able to talk about the first three today. There's just simply too much in these categories. But if you have questions on these, feel free to let me know. We can talk offline or after the presentation. So let's talk about patents first. Right? There are two kinds of patents. We have inventions, so things, systems, processes, as I mentioned, and ornamental designs. But patents are all sorts of things, right? We have, what you typically think of. We have, my clicker stopped working. We have light bulbs. This is a method of a golf swing, right? We have typical process diagrams. That could be a computer software program, right? We have chemical type inventions, chemical reactions. On the far right, we have watches, mechanicals, we have boots, snowboarding boots, and then we have the Rubik's Cube, right? Games and toys. There's a whole wide variety of things that can be patented. And we're talking about what the sort of criteria are, right? There are many types of patents, generally, right? There are provisional patents, which is a placeholder. It's kind of the easy way in. There's utility patents that protect those devices and systems. There's design patents, which they protect the look of an article of manufacture. So even if your device, let's say you invent a new shoe. Shoes aren't new, right? They have all the same properties as other shoes, but it may look different. That may be patentable. Nike puts design patents on almost all of their shoes, right? All their new designs. Automobiles are the same way. Automobile manufacturers, they will put design patents on lights, door handles, the look of a door, side fenders, rear spoilers, you name it, right? None of those things are new in terms of function, but they're new in terms of how they look, and certainly in combination with the rest of the vehicles. And then importantly, you need to understand most all IP, in fact, really all IP, is territorial in nature. And what do I mean by that? What I mean is that if you apply here in the US, you have US-based protection, right? You need to apply in other countries in order to get protection in those countries. So if your market, such as for my evaporator company, is here and in Canada, I need to be in both places. And I need to think about that and strategize about that for my product, right? So what is a patentable invention, right? Let's talk about what my gentleman over here on the left is doing. He looks to be breathing through a toilet, right? This is an actual patent. This is granted. If you practice this invention, you are an infringer, right? This invention is supposedly covering a device that will assist you in the event that your apartment building is burning down. How does it assist you? You take this tube, you shove it through the toilet water, out the back, and then breathe in the clean air that's going through your vent pipe until hopefully you get rescued, I guess, right? Why was this patented? Why is this patentable? It seems like a tube, right? But what's actually patentable is the method of how you use the tube, right? The method of escaping death by smoke inhalation by breathing through a vent pipe. I'm not sure you're really better off, but just stick with me here. So it has to be useful. Is this useful? Check, right? Is it novel? Have you ever seen anybody stick a tube through a toilet before? I haven't either, right? And certainly at the time that this was patented, it probably was novel as well. And is it obvious? I guess not, right? Obvious means like, is it sort of a normal, is it related to what you would think a device would normally do, right? And we'll get more into that in a second, right? So those are the three criteria you really need to meet in order to have a patentable invention. The bar is not necessarily that high, but it's all relative to what is known and what's out there, right? So as part of the process of understanding how or whether you can patent your invention, you need to understand what exists, right? And that's one of the things that certainly as a patent attorney, I help my clients do. And there are opportunities for you to do it yourself through patents, Google Patents or free patents online and other search engine sites. The important part about patents is that at the very end of a patent is the claims, right? They're a numbered set of statements. Those are actually what the patent covers, right? And when you're pursuing a patent and when you get a patent, the claims are what you're actually covering and what you can actually enforce. Think of it as, in terms of real property, the boundaries of your house or the piece of property your house is on, right? That's what you get to enforce. We do have other parts of an application, though, which include like the specification and the drawings, and those all fill in as background information, essentially. But in patent law, the name of the game is the claims, right? Something to keep in mind. So what are the core concepts for patentability? And I mentioned this term already, which is called prior art, right? What is prior art? Prior art is anything patented, described in a printed publication, or in public use, on sale or otherwise available to the public before your filing date, right? So what does that entail? Does that entail your invention sitting in your garage doing nothing? No, that doesn't count as a public use. It's not in public, right? But if you give your invention to your friend Steve, and he doesn't have any restraints on using it, and you're like, hey, I invented this thing, go ahead and use it. That's probably a public disclosure, right? So your own work can actually be a public disclosure. Anything patented, obviously, anything in a patent that exists, or anything in the printed publication existing now or in 1783, doesn't matter, right? Anything that became before your filing date of your application will be considered prior art, right? Patentable subject matter. There are certain things you cannot patent, unfortunately. Abstract ideas is one of them. Don't ask me what that is. The Supreme Court doesn't even know, right? Products of nature cannot be patented, right? You can't go out and find a plant and try to patent it. That's a no-no. Laws of nature. So we can't patent equations. You can't patent the Arrhenius equation. You can't patent certain algorithms. Those are just not patentable. Novelty is a concept we use in patent law a lot, and that means, is it new, right? Novelty is saying the invention claimed is not found in a single piece of prior art. So if I invent my evaporator, that there isn't one like it already, exactly like it, that's shown, right? In contrast, obviousness is a combination of known elements. So it's putting a couple of pieces of prior art together, right? So again, with my evaporator example, if there is a barrel cut just like mine and there is a baffled pan just like mine that already exists in the prior art, and you combine those together, you would say that my invention is obvious. A person of ordinary skill in the art would say, oh, I'll just put those two things together. I shouldn't be granted a patent on something that people can easily do, essentially is what the law says. That make sense to everyone? Great. So what is a patent then? At the end of the day, right? You've got this set of claims, right? You've got this description, you've got some nice figures drawn up. What is it? Well, it's a vetted invention. The patent office looks at it. They evaluate what the prior art is. They do a search for prior art. They may have an opinion about whether your patent is patentable or not. You may need to make some changes in that process, right? In talking with them. And at the end of the day, if you get allowed a patent, it allows you to exclude others from making, using, importing, selling, or offering for sale your product, right? It's not self-effectuating, though. There are no patent police going out helping to enforce patents, right? So your work is not done once you have the patent. It's a tool as part of your asset arsenal, right, as you go forward. It is information as well, right? If you know you can or cannot patent something, you may decide not to do it, right? That could be valuable. If your company rests on being able to exclude others from a marketplace and you know you cannot, that could be important to whether or not your business is going to be successful. You may need to change course. You may need to reinvent, right? You'll also learn something from the prior art. I have several clients that look to the prior art as inspiration for where they should be going, right? The documents themselves are very detailed. They describe in pictures and words how to make and use the project that their competitors have decided they wanted to do. But it gives you a window into what their thinking is, right? And where they may be going. You can invent to the left or invent to the right, or maybe you invent ahead of them and stop them in their tracks. There's certain strategies that we can use that way, right? It's an asset, right? I've said that a number of times. So you create company value. There are certain studies out there that show a company with patents is worth 8 times more than a company without, right? If you're attempting to sell. And certainly this is no more evident than when you're looking in Silicon Valley. Of course, with these software companies and what Facebook is doing, what Google is doing, and how many patents they're filing on a per day basis. And IBM was certainly no slouch when they were sort of up and rolling altogether. I mean, they were filing or having issued, I believe, 3,000 patents per year, right? Licensing for IBM was one of their biggest income streams from those patents, most of which they never used themselves. They just had people inventing, right? So it can be a tremendous asset for your company, including protection. So what are the biggest issues facing patents, especially at the entrepreneurial stage? It's timing, right? Money's tight. Always is for new companies. Patents need to be filed as soon as possible. As soon as you have the idea, the standard is, can you explain to somebody in your own words how to make and use the invention? Can you describe all the component parts? You don't have to have a prototype. You don't have to make it. But can you describe it? Can we put it on a piece of paper, right? We're in a first-to-file system. It's entirely possible that somebody's thinking of the same things you are right now, right? So it's a race. It used to not be a race. 3 years ago, it wasn't a race. Now it is, unfortunately. This is how the rest of the world works, and the US decided to go along in 2013, right? I guess that's 5 years ago now, my goodness. Anyway, so you want to work as fast as possible to think about filing patents because you can get preempted by others. Foreign rights. I mentioned before that foreign rights are territorial, right? Well, the additional factor is that foreign rights are expensive. It's another part of your IP strategy. If it is important to you, you need to plan out and budget for it, right? The fortunate thing is you don't have to do it all at once. And a competent IP attorney or patent attorney can help you strategize what your cash flow is going to look like, and they should help you do that, so that way you can plan ahead for these types of events, right? It's critical that you do so. And as mentioned, so the overall cost, especially for utility patents, can be expensive depending on the invention at hand. How expensive? I'm sorry about the eye chart here. It's a little bit hard to read, right? So this was for a client that I have that has a sort of fairly simple mechanical style invention. I can't tell you what it is, it's confidential, but needless to say, it only had like 4 working parts, okay? But he wanted to understand he needs to go foreign, he needs to go to Europe for sure, but want to understand how his costs would be distributed over time, right? So here we have a search, right? It's about $1,000 to conduct the search, hire a professional company to look at what the prior art is and to have it evaluated. We evaluate that for another $1,000, right? So you're about $2,000 in. Then we decide whether we're going to patent something, right? We have our options, right? So we can do our provisional application for about $3,000, right? Or we file what's called a PCT, or Paris Convention Treaty application, right? Which is a foreign placeholder application, okay? That would go for about $7,000 with the filing fees for that application, right? Or we decide to file direct, which means we just go straight into the country and do a regular application. As I mentioned before, the provisional is kind of a placeholder, so you have to do something within a year. So we go to the next step over, right? Within 12 months, we have another decision point to make, right? If we follow this route. And you can see the sort of the concomitant costs there. The costs are a little bit less after you file the provisional because you've actually done some work, right? So some of the work can transfer over, some of it's still in filing fees. You're looking at a direct US application after filing provisional, about $3,500, or filing a direct EU application for the entire European Union of $10,000 to prepare and file, right? If you don't go that route, let me take one more step. I'm going to stay up on the top line here. This top line here, we have, if you file this PCT application, the interesting thing is it's, like I said, it's a placeholder. So then you have to decide what countries you want to go into, right? Each country is going to have its own fees, right? So if we want to file that application in the US off that PCT, that'll be another $1,800. And if we want to file that in the EU, it'll be $10,000. Now you say, why would you bother? Like why would you pay the extra money for the PCT? Well, it gives you time. It gives you another 18 months to either raise funds, to decide where you want to file. Potentially, you're looking at, do you want, I certainly have clients that have said, I know I need to file in the US and one other country, but I'm not sure where I want to file right now if I want to file in other countries after that, right? This gives them 18 months to look for funding sources and to try to decide. It's costly, but it is a way to delay those costs, right? So again, this center line follows the same as that 30-month line over there. If you file direct, right, we look at an initial US application of around $5,500, and then we have 1 year to file that European application or other foreign applications, and that would be $10,000 at that point. But there are countries that are more or less. I can tell you Canada is about $2,000 in terms of fees and sort of things that you would add on. So that's not as much as Europe, obviously. Japan is even more expensive than that. There's also an extensive waiting period. If you file in Brazil, your application may not be looked at for 10 to 12 years, right? Whereas the US application is going to be about 2, right? You're going to wait about 2 years to have it looked at. The EU, even after once you get the EU application, you have to apply into the nation states, which are kind of these small little itsy bitsy fees you get to pay at the time. So it can be quite expensive, but you have to think long term and think about what your plan is, right? As long as it's within your plan and you budgeted for it, it's not going to be a big deal, but it is something you need to think ahead about, right? So should you patent, right? Well, do you have a core of your product that is novel and non-obvious? And notice I didn't say your product, right? Because rarely is a whole product patentable. Apple does not patent the phone. They patent the pieces of the phone, right? A long time ago, they patented the capacitive touchscreen, right? And they have also patented other features within that phone. That's what they've done. They patent pieces. So when you're looking at your product, you want to say, like, what is critical to my product? What's really new about this? What's the linchpin that holds this thing together that is really different from what others are doing, right? Of course, you would love to try to patent as much of your product as possible, but typically that's just not available, right? As I mentioned before, can you describe and show your invention? No prototype needed, but can you do that, right? Your patent attorney should not do it for you. I've been asked to in the past. It's a little uncomfortable. Just because then I'm the inventor, right? If you tell me I have an idea about how to fix this problem and I say, like, well, I would do these 3 things, that's my idea. That's kind of, I don't like to do that. Is there a market advantage offered by your invention? There's no reason to patent something if you're not getting you something out of it, right? Having the piece of paper and spending the money is not necessarily always going to be worth it, right? It's something to evaluate. And, have you made a disclosure that could foreclose patent alien invention? So that's kind of looking in hindsight. You've developed everything. Do you need to get going on that process? As I mentioned, you can create your own bars to patentability. You may want to think about it a little bit more if you're going to change or involve the product in a couple of years. If you think it's going to materially change. I have certain clients that are continually innovating, right? Their products are only going to be good for 1 year. There's really no reason to patent it if it's only going to be around for that short of time. You're not even going to have an issued patent by the time it's gone, by the time it's off the market. Which is actually why most clothing manufacturers do not patent purses and scarves and other things that are technically patentable under design patents, but because fashion industry changes so fast, they don't get any value out of it, right? Are competitors actively patenting the space you're interested in? You may want to think about whether or not you want to be in that space, right? Is it too risky? Do we need to invent something different? Or reconsider how your product is being developed? And we're not going to talk about trade secrets today very much, obviously, but is your invention maybe more valuable as a trade secret? Is it computer code that'll never be released? Nobody will ever see. Performs a great function, right? That would be harder for somebody to to either to reverse engineer or figure out themselves. It may be more valuable long term as a trade secret, and it's something to talk to your attorney about at that point. Okay, so I don't want to spend too long about this, but I want to talk a little bit about my evaporator, right? So this is what I invented. Now I'm going to tell you flat out, I was on YouTube thinking about how to invent an evaporator, right? I was doing that. I was thinking like, oh, there's got to be some product that I can look online and find. Leader evaporator is huge. They should make something. Or Grimm evaporator, which is out of Ohio, they should make something. And then it's like, I looked around, I didn't see anything. And then I said, well, what about some backyard units that people are already making? And YouTube is a great resource for that, right? What are they looking at? Well, it just wasn't cutting it. They just weren't that good, right? So what did I invent? Well, evaporators have been around forever, right? I mean, according to some of the research that I've done, people have been making the Indians were making maple syrup before, Native Americans were making maple syrup before Europeans came over. They taught the Europeans how to make maple syrup. Morse Farm, which is near where I live in Montpelier, has one of the first patents from the 1800s on an evaporator. So they've been around for a long time. So how in the world could I possibly get this patent? Well, when you think about it, what did I really do? Well, I figured out how to insert this baffled tray inside the barrel, which wasn't what people had typically done, right? Most of them had built up sides. They had actually welded up a structure on top of this barrel, actually all of them had, to allow for a wide tray to be placed on. So they had added a lot of material and a lot of time and labor in trying to change the design of the barrel, right? So a little bit like our friend who has the method of shoving a tube through the toilet, right? The method of how this is made is what the patentable aspects are, right? Okay, I'm going to move on to trademarks. Does anybody have any questions on patents while it's kind of fresh? Obviously, if you have specific questions related to your own devices or technology, yeah?
I guess my question is, how do you distinguish between, like, obviously your patent there has aspects of somebody else's patent, such as hinges on a door,
Yep.
or like,
Yep.
whatever. How do you distinguish whether or not that is, like, do you have to pay royalties to the patent that was, I mean, I guess that's...
So how would you know whether, let's say there's a patent very, very similar to what I invented, how would I know whether I should do this or not, or we should think about?
I guess, yeah.
So, I mean, one of the things you'd look at is you look at, okay, what did the patent claim at the end say, and am I actually doing it? So you'd read through it and be like, am I actually doing this? And you'd say, okay, maybe. And then you'd say, okay, is this, you look at my own strategies and how I advise my clients, and you'd say, okay, well, who owns this patent? Is it an individual? Is it a small company? Is it a large company? Right? That's an assessment of risk, right? What have they done with it? Have they paid the fees that are associated with renewals? Like, is it still alive, right? If it's not alive, I don't have to worry about it at all. I may not be able to patent my own invention, but I'm not an infringer, right? So you'd assess that, and then you'd make a determination about how important is it, and can I invent around it, right? So you look at the claims, and you say, can I get around this? And be like, yeah, I think I have really good arguments that I can get around this. And you either proceed in face of that risk, or you reach out to the guy or the company and say, hey, I'd like to take a license. This is what I'm doing. I don't think we're competing, right? Or I don't seem to be competing. The last option is something I've honestly never done for a client. We've never gotten there. Most of the time, they would just rather, because the potential risk of exposing yourself usually outweighs, what the other options are. And usually inventing around is what we try to do. That make sense? Yeah. Yeah, Denise.
Justin, what if your invention has components that other people own, like the hinge, or the barrel, or the stack?
That's a good question. So let's, obviously pans have been around for a long time, but let's say that this baffled pan is still patented and there's still a patent that exists on that, right? I would be an infringer, even though I combined it with my other stuff. If I produce this product, right? I would be an infringer. What would I need to do? I need to take a license of some sort. So that's a really good point, because getting a patent, even if I patent this, I don't necessarily get a license or the right to build it. Right? Does that make sense to everybody? Somebody else could patent smaller components of it or individual pieces that could prevent me from building my device, even though I patented a different composition of parts. Right?
Because you didn't have it in your claims?
Well, no, because they've already patented the smaller piece. Let's use the phone example for a second, right? Let's say somebody had invented the capacitive touchscreen before Apple launched their phone, right? The fact that Apple has a whole bunch of other technology in their phone and sold it on the marketplace is completely irrelevant. They have a capacitive touchscreen. Therefore, they are an infringer of the capacitive touchscreen patent, which is why, as mentioned before, when you're looking for the core of your product, you want to distill it down to the smallest critical piece. Because if anybody has that piece, you can stop them, regardless of what is in, right? Yeah.
So I guess, just to clarify, so the way you sort of, or like the way someone would design around it, I guess the way you use that product is how you got around that then, because otherwise you'd be paying royalties for the hinges and all the other little
Yeah, well, I
components.
mean, in this case, all the patents have expired. So I would never be paying royalties. I just wouldn't get a patent on my own product. But yes, in that case, you would have to do something different, right? You know, Apple would have to invent a different type of touchscreen.
But it can't just be changed in like the way it's written, I guess, in a sense.
Probably not.
Okay.
No. No.
And is there any lowest common denominator? Are you looking at every little screw, every little?
No, generally not. I mean, one thing to also consider is that in any product you're buying, like we aren't making every part to this, right? So a patent stops you from, you know, making, using, or selling somebody else's invention, right? But if I buy it legitimately from you, so in my Apple touchscreen example, if I buy that touchscreen from the company that makes the touchscreens or has a license to make the touchscreens, I'm in the clear. I don't need an actual license from them because I've got a constructive license that passes from the purchase of the product. Just like you guys all have technology on your person probably that is patented. You are not infringers by using it, right? At least I don't think so. But you guys have a right to do that. You guys can resell your phones, right? Even though it's patented. That's not a problem. What you can't do is make another phone, right? You can't make another one. You get a license when you buy something. Same thing, same rule applies in copyright. Like you can buy the book, you can sell the book, you just can't make another book. No copies, right? Okay, great. Let's move on to trademarks. All right? So, what is a trademark, right? And why do we protect trademarks? Trademarks are brands, right? It's marketing material. It's stuff you see every day, right? Business names, product names, right? We'll get into some details about what those are before, but why do we protect them? Well, the early thought was this was a form of advertisement protection, right? So we wanted to protect not only the producer of the device or the seller, right? But we wanted to also protect this image of quality. We wanted to mean something. We wanted people to produce a device or a component or a thing, right? And stand behind it reputationally. And we wanted customers to know that if I buy this thing, this widget from Smithco, that Smithco means whatever Smithco wants it to mean. Quality, cheapness, right? What do you think of when you think of Walmart? Cheapness, right? Walmart brand stands for cheapness, right? They're the lowest price, right? What do you think of when you think of Nike? Sports, fast, you know, do you think of quality? What do you think about Apple? Innovative, quality design, right? Right? So those are brands that people are building. These are marks, and this is the reputational piece that the early thoughts of trademarks were trying to do. But the more modern understanding of what trademarks are really for is to reduce information and transactional costs. It's to make things easier for consumers. We can look at a product, we can look at an Apple product and say like, oh, that's an Apple product. I have a good idea about what that's about, right? And I'll buy that based upon the fact that it's an Apple product. And I know if I don't see an Apple product, even though the product may look really similar, but it doesn't have that name next to it, I'm not sure about the quality of that product, right? Right? Which is why when you look at knockoffs, they're often changing the letters of the brands just slightly to hopefully confuse you that you'll think that it's the same quality, right? That's what they're trying to trade off of. They're trying to trade off the reputation, right? So a trademark can be any word, name, symbol, or even a device. It can be a color, it can be a sound, right? That defines the source of the goods, that relates it back to where that good came from, right? Distinguishes the goods and services from those of others, right? We don't want things that are substantially similar to another. That doesn't help us with those transactional costs, right? Transactional costs don't get easier if it's Smiths and Smiths. I can't tell, right? And stands for the goodwill associated with a product or service. The key to obtaining trademark protection is use, at least in the USA. This is not the same as all countries. Each one has their own law. We have two ways to protect trademarks in the United States. One is common law. This is just you using the mark in commerce, right? You have a product, you name it widget A, you sell it. You have now used your mark in commerce, and you have some protection, usually regionally based to where you sell it. So if you're selling your stuff in California and Washington State and down in Texas, you've probably got national coverage just by virtue of selling in all those regions. The other way to do it is to federally register your mark, which is going through the U.S. Patent and Trademark Office process and actually registering your mark with them. We'll talk a little bit about the benefits of those a little bit later.
Can you register at the state level as well?
You can register at the state level. Most people do not, mainly because it only protects you within the state boundaries, and your own use, your own common law use would do that regardless. You're never going to be limited by, if I sell my evaporators in Montpelier, I'm not limited to Montpelier. They're going to limit it to, this basically the state, probably even the region, just even based upon that one sale, right? So there's not a lot of meaning to it. One reason that people do it is if they're concerned, if they're not really interested in, it's significantly cheaper to do than a federal trademark. And if they're not really interested or worried about federal protection, is it puts a clear line in the sand that others can see, because it's on the registration at the state, that can be found by others, and they wouldn't necessarily pursue that mark and cause problems for you later. So it can be kind of a preemptive assistance in that regard. Otherwise, you're relying on them finding you on Google and expecting them to know kind of what you've used it for. So there are 5 categories of trademarks. That's technically wrong. There's only 4 categories of trademarks. We're going to talk about 5 things. There's 4 categories of trademarks. The first is fanciful marks. These are made up words, right? Xerox, Google, Exxon, all made up, right? The next is arbitrary. These are real words, right, that are disassociated with what they provide. So Apple for computers, Tundra for automobiles, Camel for cigarettes. Then we have suggestive words. These words go into the gray area where you need to think a little bit more about, you can think about what products they offer based upon the word itself, right? Microsoft, okay, it's small and there's software involved, right? You can think of Coppertone, Ticketmaster. It takes a little bit of thought to understand exactly what's going on. Not a lot, but a little bit, right? Then we fall into descriptive marks. Descriptive marks are things where the mark itself identifies some quality or feature of the products that are actually being sold. And I know Staples sells way more than Staples, but they also sell Staples, right? So Staples for Staples is descriptive, right? Can anybody guess what they offer at Tractor Supply, right? Not that hard. This last one, they said this is not a mark. So generic marks, which is not correct, generic words cannot be trademarks, right? They can never be a source indicator. We can never have a company called Car that sold cars. You could have a company called Car that sold lemonade.
Isn't there cars.com?
There is. Is it trademarked?
I don't know.
Yeah, I know. And what is it offering? It's probably offering software, right? Even is, right? That's how most of those companies do try to get around that. But like hotels.com is not trademarked. They actually lost at the federal circuit. So they could have gotten better advice on the front end. Yeah.
Actually, you could have a car company called Car, you just can't trademark.
That is true. Yes. It would just never be considered a trademark. You couldn't enforce it as a trademark. Right. Yeah, you're right. Exactly. Yeah.
Yeah. Can you comment on what you do with a generic descriptor? For example, Standards for Lycra or photocopy for Xerox?
So as a mark itself, because I don't know that photocopy is used as a trademark.
No. But all of these stories have had a story where they had to come up with something so that their actual trademark doesn't become the generic
Yes.
descriptor, like Xeroxing is a verb,
Yeah.
and
Kleenex.
Kleenex is a
Kleenex,
tissue.
yes.
and so on.
You're right. So there is, in order to, when you're using a mark, you do not, it's called genericization, is the official term for it, right? And there's actually a really funny commercial you can find on YouTube It's a group of lawyers that sing the song about using terms appropriately for trademark purposes. But yes, you do not want to use your word as a verb or as an adverb to describe a function, because then you can genericize your mark itself, which means that a word that you otherwise was a mark becomes the actual thing, right? What's that? It becomes generic, like
branding.
yeah, like aspirin.
What about Google?
There you go.
It's on its way, right?
I mean,
It potentially.
They
We
go
use
from
it that
being,
way.
Yeah,
Yeah.
fanciful to.
It is quite. There is an actual there has to be an actual process that goes through at the United States Patent and Trademark Office to call a word generic that is currently registered. It's quite extensive, and I can't remember the last time it was actually done. But you're right, it is on the way. It doesn't just become generic by virtue of common law usage. It actually has to be found generic at the United States Patent and Trademark Office or at the federal court level.
If it does become generic and then falls out of trademark, what are the consequences for the company?
Somebody else could start a company called Google. Yeah, somebody else could find a company and they could start. But at that point, if that's where you're at, would you want to start a company called Google? If it was a generic term, you wouldn't be able to distinguish yourself in the marketplace. It wouldn't be very valuable, right?
Does that have anything to do with the fact that their parent company is now called Alphabet?
I do not know. I don't think so. I think it's because they actually needed an umbrella company that houses all of their other little pieces that they've taken on. And it probably was for tax purposes and corporate structure.
Okay.
But that's just a guess, honestly. Okay, so we went through the 4 categories in the generic part, right? Why is strength important, right? Well, it's important because the stronger your mark is, the more protection it's actually given, right? The broader the scope of protection you actually get. There's a word we use in trademark law called whether a mark is inherently distinctive, right? You can see that the top 3 categories, fanciful, arbitrary, and suggestive, all get this inherently distinctive categorization. From the Patent and Trademark Office's perspective, what that means is that when they see the mark, as long as there's no conflicting marks, so similar marks that already exist for similar goods and services, they say, okay, we'll give you this mark. You can have this mark. That's fine. You can use it for your company. If you fall into this descriptive area, you have to prove that it acquired distinctiveness, right? Typically, that is a fairly substantial showing. It's usually 5 years of continuous use, right, with no competition for the same word for the similar services, right? So this is not really where you want to be, right? But all of our brains, let me ask you a question. How good of a mark is Vermont Evaporator Company? I'm a trademark attorney. It's okay, you can be honest with me. It's pretty descriptive, right? It's a pretty terrible mark. It was not a good choice, right? Now, why do we do that? Why do we pick marks like that? Because it tells people what it is. It's an easy sales pitch, right? I tell you, Vermont Evaporator Company, you guess we're from Vermont, we're a company, and we make evaporators. Piece of cake, right? I don't have to do any other marketing. I don't have to explain to you what it is. I don't have to convince you. I don't have to tell you anything, right? Now, our product is called the sapling. Good mark or bad mark? Pretty good mark, right? It's probably an arbitrary mark. Sapling for evaporators, right? Maybe it's a suggestive mark. Doesn't really matter. It's in the inherently distinctive category. Much better choice. Pat myself on the back for that one, right? This could potentially be a problem. I'm going to tell you, this could potentially be a problem for our company in the long run, right? If we may never be able to trademark Vermont Evaporator Company. And maybe if somebody wants to buy my company someday, they're like, oh man, what a terrible name. Why'd you do that? Right? They may say oh, I'm not going to buy it for X dollars. I'm going to buy it for half that because you got a terrible name. Who knows? My wife may tell me to change the name someday. That just may happen. But that's why we all fall into this. That happens all the time. I deal with marketing departments, and they really, really, really like descriptive terms. You see them all over the place, right? You see them on all products. You see them on cereal boxes and soaps and everything else. They love them because people really know they can really latch onto them. But they're not good marks, right? You really want to be over here. These are hard, though. You have to actually invest. You have to invest in branding and asset management, right? You have to talk about it more. You have to get it out there in the media. You have to put it in magazines, and people have to explain what it is. I mean, if there are VPR listeners in here, you probably hear this company Atlassian every once in a while, right? What the heck is that? They have to explain it every time, like what they provide and all the products they provide, right? But they do it over and over and over again, and they build a brand. But that's what you have to do. It's hard, it's expensive, but at the end of the day, it'll pay off. But it's a long-term vision for that, right? Okay, so what are the other influences on the strength of the mark? So we talked about the type of mark, right? Whether it's fanciful, arbitrary, suggestive, right? How many other marks are similar to it, right? Even if you have a suggestive mark, right? You're Microsoft, and there's other types of similar of marks that are selling software services. That will lessen how strong your mark is. On the other hand, if you pick something completely arbitrary that has no other thing that's close to it, you're going to be given a really wide berth in terms of protection. What does that mean? That means when you go to enforce it, people are going to be like, no, the idea of enforcing a mark is based upon likelihood of confusion, right? And really, when you look at that, you look at intent of the user, right? So if you had the mark Xerox, let's say you came out with Xerox. Xerox is a made-up word, means nothing to anybody, but then you come out and you're like, I'm going to make a computer company called Xerox. Any court or any jury is going to sit there and be like, why would you pick a mark that was so similar to this mark, even though it has a T instead of an X? Like, I know it sounds different. I know it looks different. But why would you pick that? It's completely, there's no reason for you to be that close. So they would give Xerox a wide berth, right? So that's one of the things to think about when you're choosing your mark, is to understand, how are there other marks that are similar? Twitter was picked out because of a dictionary term, right? He was flipping through the dictionary and picked out words. Some people do that. It's a way to start your process. The acquired strength of the mark. So not only can your mark start off strong with being arbitrary or inherently distinctive, continuous use of the mark will add strength. The longer you use your mark, the stronger it becomes, right? Up to a certain point, you get to be famous. We all know certain famous brands. Coca-Cola, Pepsi, the list goes on and on. Gucci. Like, there's all sorts of famous brands around. Those are long-term marks that have been used for a long time that are known in the marketplace, right? And those brands, and once you become famous, you get dilution rights, which means that people can't come really even vaguely close without infringing your mark, right? Sometimes even in product categories that have nothing to do with what you've got. So think about it this way. Do you think you could sell a car under the name Coca-Cola and not have somebody think that somehow Coca-Cola was related, right? No. You can't sell a car under the name Coca-Cola, even though it has nothing to do with what Coca-Cola does or what they've registered it for, right? That's how strong that mark has become, right? And the product and services offered on the mark. So the broader your scope of products and services, obviously the more coverage you get, right? And if your products and services expand, you become a small empire company, you honestly get more and more protection. Yeah?
If you have a trademark like you were just explaining, and you do start expanding your product offering, do you have to amend or modify your trademark from when you originally filed for it?
It depends, but generally yes. And what you actually do is file again. You just file a new application. It really depends on how you've described your goods and services in the first instance. So if you're a consultant offering consultant services and you have, let's say you get the services described are consulting services, right? It doesn't really matter then what consulting services you offer. They're all included within that first application. But let's say you change and you're going to start providing charitable services that would be a separate application you need to file, right, to cover those expanded goods. It depends. Working with a trademark attorney should help you sort of think about how to make that as broad as possible, right, depending on what you're doing, and also think about your future plans and try to include that, or try to include language that will cover at least your near term, so you're not filing multiple applications. A typical trademark application, which costs about $1,000, sort of all in, right? Okay, so here's our quiz, all right? So this commercial was playing this fall. There's going to be a number of trademarks that are going to be, well, there's going to be a number of names that are going to be mentioned in this commercial. And after this commercial is over with, we're going to try to classify them into the 4 categories that we talked about before. Uh-oh. Where'd it go? Let's try that again.
These new Fruit of the Loom breathable underwear are perfect. They need a name just as perfect. Cool's Gold. The Pants Snorkel. Briefs. House of Mesh Representatives. Shiver Me Trousers.
Pantarctica.
Fruit of the Luge. Thank you, Marvin.
Breathable underwear?
Mr. Meshy goes to Windington.
Breezy Foshizi.
You're a genius. We'll call it Breezy.
No. We're gonna call it New Breathable Underwear by Fruit of the Loom.
All right. Okay. So I'm not going to ask you to remember them all. Oh, that's not good. Oh, man. Okay, so I'm just going to tell you. You already got the first one. That's unfortunate. Okay, so Cool's Gold, right? Why is it arbitrary? You remember? These are real words, right? Describing a product, but obviously has no relation to the product, right? Okay, so the next one, Pants Snorkel. Descriptive? Think so? I would tell you this. Everybody's entitled to their own opinion, because the Patent and Trademark Office certainly is. And there's no really incorrect answers. So, Pants Snorkel, I threw out there arbitrary, mainly because these again are real words, right? Briefs.
Descriptive.
Yes, that's right. Why is it descriptive? What do you think?
They're short pants.
Briefs is a universally, I think, known as another word for underwear. So it tells you what.
But I said it funny. Shouldn't that count for something? No, it doesn't.
Oh, briefs as in like a. Okay.
It doesn't count for anything, though. Funny spellings don't matter, right? The USPTO looks this over completely, and they would just say this is briefs, right? Right? So that's why it is descriptive. It wouldn't actually work, right? Okay. Shimmy me trousers. Shimmy me trousers. Yeah, probably maybe suggestive. It's cool. It's in your pants. Oh, there we go. I did that one too. Sorry. Pantarctica. I put that as suggestive, right? This is interesting because this is not a real word, right? But what the USPTO will do is actually split the word. So they'll say like, well, actually, what you meant was pant and Arctica, and they'll be like, cool pants, right? And then they're like, then they'll be like, oh, well, that's completely descriptive. That's what they'd argue, and then you'd have to argue back. And but that's how the Trademark Office works. So, okay, Fruit of the Luge. Probably arbitrary, right? That just hints on their name overall, right? And the last one, the second to last one, breathable underwear. Did Fruit of the Loom just make the same mistake that I did in picking their name for their underpants? Yes, they did. Yeah, absolutely. Yeah, they picked the descriptive one. Breezy faux cheesy. Yeah, so this is, I would probably put this one in fanciful, because these aren't real words, right? This is a, I believe there's a rapper or something, right, out there? Yeah?
Yeah, I feel like you've given us definitions of what arbitrary, suggestive, and descriptive is, but so far I'm not clear on what fanciful means. Maybe you're getting to that?
Yeah, so fanciful is made up. It's a made up word, right? So that's what Xerox is, Google's made up, right? Those are made up words.
Yeah, so if it's a made up word, what is Antarctica then be fanciful?
Well, you'd actually, so the U.S. Patent Office would split this word. So together, yes, it's an arbitrary, it would be fanciful. Like Pantarctica doesn't exist. But the USPTO would actually, this is an example, they would split it into two real words, right? So you can't just cram words together to make a mark that's different, right? You can't use funny spellings, right? Foreign languages, also not really going to help you that much. Yeah?
But isn't Google just a different spelling of the word Google? You know, with the numbers?
Potentially. Yes and no. But I guess it depends on what the office is looking at in terms of what the funny spelling is. Like funny spelling, usually the funny spelling thing comes into play typically when you're in the descriptive area and you're trying to get around being descriptive by putting in a funny spelling, right? These are, like I said though, it's all, I've been doing this for 10 years and I'm routinely amazed at what the trademark office pops back at me, even though what I've thought. And I go and talk to my colleagues at the law firm, and I'm like, what do you think about this mark? And they'll be like, I think that's fine, and then we're wrong, right? It really depends on your perception. Sometimes it's about knowledge base. The trademark office is in Washington, D.C. I certainly have had where they just aren't concerned about certain products that I would think would be somewhat related, and they say are okay. It's really interesting.
How does the design fit in, Justin? Like Google has a clear color palette. Some of these things may have a clear color palette or a font.
So you can trademark a number of different aspects of a mark, right? So you can trademark what's called a standard character mark, which means just the letters themselves. In any font, any color, any stylizing you want to do, right? It covers all of them, right? But then you actually find that sometimes you want to cover the actual style in which you produced your mark, right? So whether it's Google's outlining the font that they use. I use this example a lot. Expedia has marks to the word Expedia, the Expedia with the sun, Expedia with the plane without the sun, the plane in color, the plane in not color. I mean, they have 40 different marks to just that little piece, right? I would not suggest that for any of you, right? But when you're at that size and you want the maximum amount of protection, you apply for all those things, right? And that's what the really, really large companies can afford to do.
Is there any cost to keep it? You pay one time, and as long as you don't change it, do you have to annually?
So for trademarks, you have once your mark is allowed, in 5 years, you have to show the office that you're still using it, and you pay a fee. And then another 5 years after that, you do that again. And then it's every 10 years after that. So, but it can go on into perpetuity. As long as you're using the mark and you have to show a specimen, you actually have to show a picture of the product with it on there or a website, then you just get to keep using it. Yeah, it's a good question. Okay, so what mark should you choose? Well, you want to choose a strong mark, obviously. I tried to make that point earlier. You want to watch out for common pitfalls. You can use your name, but watch out for trying to trademark your name, right? So there are certain situations where you can trademark a name. Certain names are trademarked. They need to be relatively famous and relatively how do you want to say this? They need to be very uncommon names. Generally, less than 1 person in 100 in the United States need to share that name in order for it to be allowed at the trademark office, right? So if you have, using your name, you see it all the time. It's another one of those easy things, John Smith's Construction or whatever, that's an easy thing to do. Give some people an indication of what you're about. But just be careful if that's the route you go down to and understand the limitations of that, right? Known places, people love this one too. Vermont, obviously, Vermont Evaporator Company. Green Mountain, right? Allagash Beer, right? Allagash Beer is trademarked, and they were able to trademark Allagash. Another woman tried to trademark Allagash Jam, not so much, right? Similar names to others, obviously, the test, as I mentioned before, is likelihood of confusion, which basically compares the marks for what they look like, sound like, what their connotations are, and then compares the goods and services. You can use the same mark as somebody else, as long as it's not famous, for different goods and services, right? So you have, Apple for, let's just use Apple. Apple's a pretty famous mark, but let's just use it for it anyway. Let's say it's not famous. So you have Apple that does what Apple does for computers, and you want to sell Apple cars. If they weren't famous, you'd probably be okay, right? You could do that. But you want to be careful just because how close you are to the goods and services. If you were offering Apple computer repair services, probably a problem if Apple's selling computers, right? So you got to be aware of like how close you are to what they're offering. Conduct a search. The trademark office website is actually a fairly good website. It works, right? Most of the time. I would say that you can run it on different days and you'll get different answers, which happens, but most of the time you'll get to the right result. I suggest running a couple of them just to make sure. But it's fairly easy. You type in the name. You can use wildcards. You can use partials, right? They have a whole bunch of different search terms you can use to try to do that. Think long term. It's really hard to get marketing departments to want to stick with a mark. They think it gets old really soon. They're like, oh, nobody's using that anymore. We're going to switch. We're going to change. Well, all the brand building you've done is then lost once you change, right? All that work. I actually have this other company that I've worked on for a while. It's not launched. I'm not going to bore you with the story of that one, the failure that it's been so far. But I would tell you this little anecdote. We had picked a name. This is 4 years ago. We picked a name for the company. Everybody liked it. And we're working on the product. Working on the product. Nothing's launching. It's about to launch softly, soft launch, right? And we look at the name, and people are like, oh, we should change that name. We should definitely change that name. So we hire a marketing firm. We hired a marketing firm. We go to this marketing firm, and we're like, we need a name, right? And I spent numerous sessions with my counterparts trying to pick different names. So we're sitting there, and we're like, we've got this list of 10 names, none of which were the original name, right? And the marketing firm, literally within an hour, like goes through, and they're like, so what's wrong with the first name? And we're like, well, and they're like, it got stale, didn't it? It got stale, you hadn't used it, it felt stale. It's not stale. Nobody else has seen this thing yet. Just go ahead, right? But think long term. Don't switch, don't change the wording, right? Stick with it, try to plan ahead, yeah?
We were talking about common law trademark and how it needs to be in commerce.
Mm-hmm.
Can you trademark before you make your first sale?
You can apply at the federal level to hold a mark, right? It's called an intent to use application. And you can file that application, and then once it's allowed at the office, you can extend that application for up to 3 years. So essentially you give yourself about 3.5 years with which to use that mark. At the end of that time period, if you haven't used it yet, the office is like, reapply, you're going to start over. And if somebody's applied for the same mark in the meantime, you're SOL.
And if I don't go that route, but I'm developing my product and want to just kind of get the name out there, you know, again, before I made any sales,
Yeah.
I can't have a trademark on it until
So,
it's out there.
yeah, so you're not going to get common law trademark rights until you actually use the mark in commerce. So use of the mark on a website without actually offering the product or service and actually be able to provide the product or service is not enough under common law. You'd have to go with the intent to use. Yeah?
What if you put together a sell sheet? I mean, you don't actually sell it, but you're showing the intent.
So it's been ruled that an offer for sale is not enough. You have to be able to show them the bacon, right? You have to be ready, willing to perform the service, and then somebody has to accept that offer and you have to perform it. That's the rule.
I sold one to a friend.
Well, I mean, I've certainly, you know, sending a couple to people that actually do buy them randomly, that's enough. There's no de minimis use, like, issue. The Federal Circuit has said there's no de minimis use in commerce. But, you know, you're jeopardizing, you know, a little bit of your future by taking that approach. Just either get yourself in there as soon as you can, make sure your mark's clear, and get your product out there, or do the intent to use and save yourself pain. Yep.
If you're developing a game and you have people pre-registered for it,
Yeah.
could you still trademark the name, or?
Well, that's an interesting question. So you have people pre-registered, but you haven't released the game yet? So no. There's the Patent Office has ruled that they had a case where somebody had put beta on their page and they were like, to launch on X number of date, and they submitted that as their specimen. And the office said, nope, that's not used in commerce because it's actually not live yet. It wasn't available for customers to use. You may have had people waiting, but unfortunately that's not enough. So, yeah, Beck.
In the common law trademark, does it behoove you to put, or are you allowed to put the little TM next to your mark?
Yes, so the TM has no legal significance. It looks good, but you can put TM on anything you want. You can put TM on generic marks, you can put TM on suggestive, inherent, you can put it everywhere, anywhere. But it has no, what it says is that you think it's a mark, whether how wrong you may be or not, like you think it is. Now, there are some times that you don't want to do that.
Why?
If you're very close to somebody else's mark that you think is descriptive, you don't want to tell the world that you think it's a trademark, right? Because that says, because what you're going to do is then go to court. When that person sues you, you're going to go to court and you're going to say, you're going to be like, that mark's completely descriptive. And they're going to show the piece of paper with the mark and the TM next to it and be like, well, you seem to think it was a trademark last week, right? And that's going to look pretty bad, right? Yeah, back there.
You said for patents it takes about 2 years sometimes for the patents to be approved.
Yeah.
For trademarks and such, about how long does it take for those things to get processed?
You know, I tell clients 4 to 8 months in general. It depends on what, when you submit your list of goods and services, it goes into a number of classes. It's called the International Classification System. And there's 45 classes. Some classes are busier than others. Computer stuff is pretty busy. It's been pretty busy for a while. And that goes for patents too. If you actually have a computer software patent, you're looking at 4 to 5 years before issuance, right? There's just so many, and there's so few examiners, right? But in other disciplines and other areas, I mean, I had one, I had a mark just get issued in like 3 months for lubricants, right? So it can be very quick. It can be very quick. So, yes, Steve?
Is it provisional patent?
Yes.
What is a provisional patent?
It's a placeholder. So you file it. It has less requirements than the full utility application, but basically it gives you 1 year to figure it out. You file it. It sits there. It never gets looked at. If you decide not to do anything with it, it just dies. It goes into a drawer somewhere.
And you can, when can you always write patent applied for?
Oh, when you can write patent pending, as soon as you apply for a patent. And as long as you have
or provisional
or a provisional application, as soon as it's on file, you can put patent pending on your product or on your website or whatever you want, or use it in marketing materials. Yeah.
So when you come up with a hot idea and you have no money to protect it, but you could purchase a provisional patent and write patent applied for or patent pending, that provides some protection? Like someone's going to look into that? They can't see what you've done,
hopefully they think you're an 8,000-pound gorilla and you're going to come beat them up, right? Because like TM, patent pending has actually no legal significance.
Gotcha.
Right? But it does put a little bit of fear into people, right? You see that on there and maybe you decide to do something different, right? Maybe you decide to change your tactic. Maybe you decide to, mix it up a little bit, right? So it is used, the only time that putting somebody on notice of a non-issued patent is effective is if the application is published at the patent office, which means they typically publish it about 18 months after you file, right? So it's actually on the record, you can find it on Google or something, right? And then you send that application to the potential infringer. And you say, hey, just want you to know, a friendly reminder, I've got this patent pending at the U.S. Patent and Trademark Office, and as long as the claims issue in substantially the same form as they were submitted or shown on that application, you can obtain royalties from the date of publication of the patent. So it gives you possibly 8 to 18 more months of royalties that you can potentially collect. And hopefully you scare them again. Right? Denise, one more. I got to get on to copyright. You guys.
This is the last one, Justin. If you have a common law trademark,
yes.
Okay, and then somebody comes along and applies for a federally issued trademark, is that a trump card?
So no. So in the United States, as I mentioned before, we're a use-based jurisdiction, right? So first, if I use first before you apply or use, I win, right? Now, so there's actually a process at the patent office, trademark office you can use to effectuate that. So while the other mark's sitting there, you can oppose it and say like, I used this already, and then the trademark office will say like, hey, you don't get this, right? Now, there is a question about how much coverage you have. So in the situation where you have a common law trademark, let's say you've used it only in New England, you've never sold a product outside of New England, right? And somebody else registers the mark at the trademark office, they could potentially get everything outside of New England for the mark. There's a potential splitting of the jurisdiction that can happen. It's not very common, but it can happen. So, all right, guys. Let's talk a little bit about copyright. So, copyright is original expression plus fixation, right? Original, it's new, right? It's your own thoughts. It's an expression of an idea. It's not the idea itself, right? That's the concept we're going to talk about. And it's actually fixed into a fixed media. My talking today, if I was not being videotaped, would not be protected by copyright, right? The fact that it is being videotaped means that that videotape is a copyrighted work under the copyright laws of the United States. All right, so there are three elements, right? Independent creation. You were jointly with others, right? You got it from somebody else. A modicum of creativity. It's a really, really low bar, right? Really low. Like, the only thing that's ever been kicked out, really, the only thing that's ever been kicked out are telephone books. Somebody tried to sue over telephone books. And that's the only thing that really has ever been kicked out. And it's fixed in a tangible medium. That could be paper, digitally, video, sound recording, any of those things, right? It's got to be on paper though, or some other fixed medium, right? It can't be a copy. Makes sense, right? You have to have independently contrived to work, completely identical to what before. So what that means is, unlike patent law, it's the first person to invent, right? That's what we talked about. You're the first person to invent it, it's novel and non-obvious, you get the patent, no matter what else somebody else does at the same time, if you were first. In copyright law, if you and I develop the same song with the same lyrics, but we're in different spaces and never heard of each other, we both get copyright, right? There is no registration for copyright required. It automatically attaches once you fix it in a medium, right? My presentation is automatically copyrighted right now. It's in a fixed medium. There are significant benefits to registering, though, mainly in the terms of statutory damages when you go to sue somebody that prevents you from having to prove actual damages for stealing a copyrighted work. You can imagine that plays itself out very nicely for companies like record companies and other folks that try to quantify the cost of pirated materials. What's covered by copyright? Obviously, literary works, pictures, graphics, sculptures, architecture, distinctive architecture, non-functional architecture, right? Musical works, dramatic works, motion pictures, and derivative works and compilations. Derivative works are adaptations, so a movie turns in, or a book turns into a movie, or as in the case of Star Wars, vice versa, right? Compilations, joint works with others, so magazine articles are typically compilations. They're disparate authors that come together to form a joint work. Facts are not copyrightable. You don't get to own the facts, right? You get to own the expression of the facts, right? Items lacking originality, so generally facts, right? Or standard organizational principles, like organizing a phone book. Short phrases, the text in greeting cards is not copyrightable. This is sort of, again, this gets back to the principles, like we don't want to preclude the use of common words or phrases to the public. We don't want somebody suing over saying happy birthday, right? And everybody knows you can now sing happy birthday without a license, right? That's new. So we won't get in trouble for that anymore. Some contract language and standards are not copyrightable. Why do I say some? Because some of the more creative ones, of course, still fall under those auspices, but more generic type contract language just wouldn't. There's only so many ways to write a license. There's only so many ways to write an indemnification clause, right? We can't have copyright infringement happening all the time, which is why if you look at legal contracts online, you can take legal contracts from offline and use them for yourself, and you're not committing copyright infringement in those instances, generally. Patent disclosures. Part of the trade for a patent is we give you a 20-year monopoly, you give us the idea, and we disseminate it to the world, so the disclosure itself needs to be public, right? So the figures in the application are generally public, and that means all the text can be copied, right? Yeah, Steve?
So short phrases, taglines, just do it, Nike, just do it.
Trademark.
That's a trademark.
Trademark, yeah, that's where trademark comes in. Yeah?
You have like a physical product in the marketplace with an established and unique like aesthetic and look and feel. Is that copyrightable?
Ooh, that's a tough one. That's a tough one. There's some case law out there like furniture cannot be copyrighted, even if it's artistic. But there's some debate about how artistic it could be before it becomes a copyrightable work. What I would suggest for something like that is a design patent, right? Because that actually covers the ornamentation of how it looks, especially just, you can have it cover just that ornamentation feature, and that would get you at least 15 years of protection on it. But it is an interesting interesting little spot and overlap, right?
I have a question.
Yeah.
Kind of what Steve was saying. So if a company's like tagline was "just go for it,"
yep.
Like would Nike go after them at all or something?
Knowing Nike, yes. Yeah, they absolutely would. Especially, well, it depends. What were you selling? What are you selling under your "just go for it" tagline?
Socks.
Yeah, you're getting your pantsuit off. Okay. Yeah, that's a bad one.
Something completely different. Like
yeah, if it was completely different, they wouldn't have much of a case. I mean, they're gonna have to weigh that. Just do it is. I don't think it's famous. I probably wouldn't call it famous based upon the case law, but you'd have a hard time with a lot of things, especially if there's anything to do with clothing, right? You'd probably be out of clothing altogether, out of certain sports equipment, because that's where Nike is. So,
very separated, like.
Yeah, absolutely. And I'm sure there's instances, you can probably find it right now, you know, just go for it is probably elsewhere too, right?
Well,
And
the kale one, they just
eat more kale.
Eat more kale.
Yeah. Yeah, with Chick-fil-A. But the interesting thing about your point is like, so would you, if you didn't trademark that, if you didn't call it a trademark, could you say that this is just a phrase, right, that people use? Just go for it. I say it all the time. Like, why shouldn't I be able to put that on a t-shirt and sell it? This is actually the argument between Long Trail Brewing Company and Burton that they had last year on Take a Hike, right? Burton wanted to put Take a Hike on t-shirts, right, for hiking, and Long Trail uses it for beer. And they couldn't agree on that. And so there was a federal lawsuit filed.
Who won?
It hasn't been decided yet. Either that or they settled. I didn't follow it after it was last summer. But they, you know, the interesting thing is, like, Burton was saying, like, this is just a phrase that people use, take a hike. Like, we take it all the time. Like, and we're putting it on t-shirts. We're, you know, the mark Burton is still there, right? That was our argument anyway. So that's where they would kind of fall into. Yeah?
Why would they take that to court? Like, why would they just not make that t-shirt? Why? Does it become a pride thing at a certain point?
I think so. Yeah.
You know what I mean? Like,
No, yeah, I mean, those are great questions. I mean, like, this is about, you know, maybe the owners don't like each other. There's all sorts of personal things that come into play in these situations. Like, I don't know.
yeah, and then what does Long Trail want? Like a cut of the sales?
No, they wanted to stop completely. It was a complete, like, stop, cease and desist. You know, but sometimes you get these things and there's no prelude. There's no, like, hey, friendly call, like, hey, I really don't like you doing that. Could you stop? Right? There's just like an angry letter, right? You get those sometimes. And then there's an angry letter back, and there's more angry letters, and then, you know, next thing you know, you're in federal court. You know, so. All right. So trademarks and copyrights both exist on a continuum. So the strength of your copyright is basically based upon how original is it, right? What is the expression? So pure compilation of known organizations, that's phone books in alphabetical order, right? Factual matter is textbooks, right? You can't trademark facts, you're only trademarking the expression, so somebody else can take the same exact facts and make another trademark work. Historical fiction, we're starting to play around with things a little bit, maybe invent some characters, right? And then you have complete fictional works. This is obviously just revolving literary works or movies and stuff like that, but that's the continuum that exists on, and you get more protection as you go along, right? It's important to know you don't own the idea that's encoded, right? The idea is a fact, right? It's just your expression. It's called the idea-expression dichotomy in our jurisprudence. And this is an example. This was the case of Baker v. Sheldon. There's no copyright in bookkeeping the method. You could patent that, potentially. But the book on the method is copyrightable, right? This is an example. Okay, this is one area where as entrepreneurs, I find really flummoxes people, right? It's the work made for hire doctrine, right? It gets thrown around a lot. And people are like, oh yeah, this is a work made for hire, like it's completely covered, like I own that thing, right? So let's throw out an example. You guys hire a web designer, no contract, right? No contract with a web designer. You're just gonna pay them $3,000. They're gonna give you a website. It's gonna be awesome, right? Who owns that website? They do. They do. They're the author of that website. You have the right to use the instantation of that website as it currently exists. Can you modify that website without their permission? No. Right? People often think that work made for hire covers those situations, right? I hired them. They did work for me. It should be mine. How does that not make sense, right? But the work for hire doctrine only applies if they were prepared by an employee, right? So employer-employee relationship needs to exist. That certainly wouldn't include this web developer case that I just described. Or, right, it needs to be special order commission for use as one of these 8 things. Notice web design is not on here, right? and you need an express agreement. You need both parts. The work made for hire doctrine does not apply automatically, even if you're in one of these areas, right? So when you're thinking about engaging with people in the world, marketing companies, advertising companies, web designers, et cetera, You need a contract. You want to have a contract that gives you some rights over the ownership, over the materials you're paying for, right? You definitely want to consider that. Now, are there a lot of disputes around this? No. But if they come up, right, you don't have anything, right? Yeah.
So then how do you obviously people hire a number of companies for doing websites. How would you protect yourself so it's your copyright material? I mean, if they're building the website but you give them all the content, is that, I mean...
Still theirs.
Still theirs. So how do you...
You get an assignment, right? So you get a contract with them. You say, I'm paying you this. You're going to provide me with this website. And when it's done, you're going to assign all the rights you have in and to this website to me. Because you are the author of this website, but you will assign all the rights to me. Now I'm the owner of the website, right? I'm not the author of the website. These are different things. But I'm now the owner. Right? Now, yeah. Yeah, go ahead.
So the Creative Commons license, it's on like the bottom of some websites.
Yes.
How would that work? Or what is it?
Well, so Creative Commons licenses are use licenses for whatever materials are on the web pages they serve, right? So it's often associated with pictures, other creative materials that are available, and basically they spell out the terms with which you can use the materials, right? According to the author. So in that situation, you are an author, you have created something, you've taken a photo, and you've uploaded it, and you said, anybody can use this photo for non-commercial purposes as long as they attribute it to me and put this little caption on it and say, thank you very much, right? Or for software, you put in a certain software disclaimer within the software code that says this was developed under an MIT license or what have you, right? Creative common licenses like that or computer licenses like that are generally okay. There are some that are a little bit more extravagant and can actually deprive you of future IP. The GPL, the General Public License version 3, actually does that. It tries to glom on and tries to create non-patentable software inventions because the organization that created that license does not like patents at all. So that's one to shy away from, to use like a library or something like that. That's sort of getting off topic a little bit. But anyway, the important part here is try to get a contract with whoever you're working with, right? It can be fairly simple. It doesn't have to be complex. There are things online that can help you do this. And hopefully if you're working with a business, they have some, they have something that'll actually help you, that can work through this. They'll have the original agreement that you can read through and talk about, right? Okay, so as I mentioned, be careful if you hire. You know, how are you letting your works be disseminated? If you were an artist and you're putting your material online, how are you in control of that work? How are you watching what's being done? Are you putting necessary protections, you know, watermarking, various things to protect an unauthorized distribution? Or are you putting a certain license on there that allows you to enforce the copyrighted work later? If you are getting pictures online, be sure to be careful about the copyrighted, any license that does attach to it, right? I'll give you an example. I just had a client who had the image she used on her website had a Creative Commons license associated with it. It had very particular terms that need to be followed, and she didn't follow them and got a lawsuit filed against her for copyright infringement, not for breach of contract. That'd be too easy. It was copyright infringement because you didn't have a license, right? So just be very careful when you're reading through those terms and adhere to them very closely if that's the route you're going. Otherwise, pay the $3 for the image so you can just use it forever you want, right? Sometimes free isn't free. Are you working with others? Joint works become an issue, a sticky issue in copyright law, right? Because generally both parties own the works that they contributed. Or sometimes they both own the whole that they can do anything they want with, right? Best to work those out in advance if you can. And are you going to register? Decision to make early on the front end, much easier to do. Your statutory damages provisions that are allowed under the federal law really only kick in if you do it before you know of the infringement. So you don't want to find out that somebody's infringing and then try to register, which you need to do to take them to court. Anyway, I'm running really late here, so I'm just going to keep going. Risk reduction incorporation. I'm going to go through this really quickly, and we can talk about some questions at the end. So why incorporate? Well, without incorporating in general, your personal assets may be at risk, right? That's what incorporation essentially does. It's the biggest thing that it does. It puts a line in the sand between your corporate assets and your personal assets. So if somebody takes your device and does something stupid with it and hurts themselves, they only can go after the company assets. That's all that's available to them. They can't go over anything personal, right? It has other tangible benefits in terms of legitimacy, being able to raise funds, get a loan from a bank. There are other things that it does do for you. Sometimes there are tax benefits. Sometimes it allows for further investments. So we'll talk about a few of those things and the benefits. Why not? Well, it costs money, right? There are yearly fees. Sometimes there are taxes, right? If you're an LLC in Vermont, you have a $250 tax every year, or fee, regardless of whether you made any money or not. It's the minimum, right? So it's not free for that exchange, right? You need to comply with whatever corporate formalities are available or in your agreements or whatever you sign up for, right? If you don't, you could lose the protection that you tried to get in the first place, right? And then control. If you have other people involved, you may lose control of your business, right? They're not always, the more investors you get, the more they're going to be interested in seeing what their money happens to their money, right? So let's talk about a few different entity types. So this is not a corporation, right? This is a sole proprietorship. This is just you existing on your own. There is no asset protection here. You do have complete control. There are no legal agreements involved. You just shut up your shingle, right? Smith's Bakery, you're good to go. 100% of profits go in your pocket. They go right to you. You just pay taxes on the profit just like you would personal income, right? No complications, no real issues from a tax perspective. The cons, you're liable for all your business debts, which means they can go after your personal assets, right? No protection from this liability. They can go after your personal property to collect on those debts, right? And it generally can be harder to raise capital, right? Mainly there could be a trust issue. Who is the person contracting with? Where are you moving money to, right? You don't necessarily have a separate bank account. So are you mingling funds? You can do that if you're a sole proprietorship, but that's not going to make an investor very happy. Limited liability companies. These are the most common companies we form at my firm, right? They're the most flexible. They're the easiest to form, generally the cheapest, right? You can be taxed as you choose. You can be taxed as an S corporation, which means sort of a flow-through idea. So it's a flexible arrangement. You can be governed and operated as you choose. You can be member managed. So the people, if it's just you, it's just you. If it's you and another person, you can be the manager, they can be the member, or you can decide who has what responsibilities. It can be very flexible. It does protect you from liability, right? Generally, there's going to be an operating agreement if you're working with other people, or even if you're doing it solely and you want to adhere to the provisions within that agreement, right? Owners can receive profits and write-off forfeitures larger than their percentage interest in the LLC. I'm not a tax attorney. Don't ask me too much about this, right? All I know is that you can get into real trouble if you do it wrong, right? Corporate attorneys, and I certainly do set up corporations, but we're still not a substitute for competent tax counsel, right? And typically my firm and your accountant would work together to come up with the best plan and make sure we got all our I's dotted and T's crossed. There is a thought out there that LLCs sort of have a harder raise of capital, mainly because it's how the LLCs are structured at the beginning and how you would add shares. There's no shares to distribute. You're distributing units. It just becomes a little bit more complicated. There's more paperwork involved. If there are multiple members, you'll need to prepare K-1s for everybody. K-1 is a special tax form. It goes out to all your members. They get some sort of distribution of the profits or losses. Can get a little complicated. I think our evaporator company now has, I want to say we have 8 investors in the evaporator company, but we also did a milk money campaign where we raised funds, which would add, if they all come on board as shareholders, which would add like 60 to 70 more investors, which will be a lot of paperwork. So we'll see how that works out. Again, that may be a bad choice. We'll find out. The tax consequences if you do this bullet thing, as I mentioned, right? Okay, corporations. So it may seem like weird that you do a limited liability company or a corporation, but corporations are a special structure under the U.S. code. They do protect your assets. Many of you may know there's two types of corporations, kind of. There's the S Corp type corporations and C Corps, right? They're just tax elections, right? Depending on what type of corporation you are. Sometimes you can be an S Corp, sometimes you can't, depending on the number of members. Anyway, there's a tremendous amount of credibility associated with being a corporation, but there's also a tremendous amount of paperwork involved with being a corporation. Easy transferability, you can sell shares, right? Even as a private corporation, you can easily sell shares to other people. They have a par value, you evaluate them, you sell them to somebody else. You can easily increase the number of shareholders. The company can create more shares, right? Less flexibility when it comes up to dividing up profit and loss. It's based upon the number of shares you own, generally, right? You can lose your S Corp status if you file your taxes incorrectly, which could have negative tax implications. There are stock restrictions on transfer, some instances, and the number of shareholders is limited for S Corps to, I believe, 40. So if you have more than that, you're limited. Okay, last slide. What else do I do at my firm? There's a lot more to IP than what we just talked about. This was really just about sort of setting the foundation, right? There's licensing. There's non-disclosure agreements that you may want to sign with other parties you want to talk with. There's IP acquisitions. Do you want to buy intellectual property from somebody else? There's litigation and enforcement. Do you need to sue somebody? Are you being sued? Right? Administrative proceedings. Did somebody challenge your patent at the patent office after it issued? Right? Opinion drafting. Do you need somebody to give you an opinion to avoid a claim of willful infringement? Right? That's another thing we do at our firm, and a number of other things as well. I want to thank you all for your time today. I apologize for going so long, but thank you very much. What's that? I'll take as many questions as you guys have.
One
Yeah.
or two last questions.
Let's go.
Okay.
So B Corp is actually a special certification that you apply for, and it's run through B Labs. And if you call them, they have a questionnaire you fill out, and you do some other things. We're actually, right now at my firm, trying to become a B Corp. That's why I know a little bit about it. But it's not a corporation status per se. It's just a certification. Yeah. Yeah.
Couldn't you mitigate any? Okay. Couldn't you mitigate any liability from using your product with a user license agreement? Like at the
Potentially.
time of-
Potentially you can, and you should, you know. But there's going to be certain instances where that's not going to cover you, depending on what happens. I mean, some things you can't actually agree out of, according to law, right? If you have an inherently dangerous product, that's not something you can do. Sometimes those agreements aren't going to cover every single possible use. Excuse me. Think of the Samsung battery phone issue that was blowing up, right? Not something you can tell somebody that, oh, you bought it, sorry, and you've got this contract, right? Sure, if their phone breaks, they don't have any recourse unless it's under the warranty period. But something like that, you're out of luck. Samsung's responsible, right? Any other questions? Yeah.
I'm sorry if I missed this in the beginning, but in order for something to be considered IP, does it need to fall into one of those, like patentable, trademark, or patented, trademarked, copyrighted, or
Trade secret?
trade secret?
I mean, no, what were you thinking? Or do you want to talk offline about that?
Like if there's a company acquisition that includes all IP, but there's nothing trademarked, nothing, nothing that falls into any of those four areas. Is there any IP?
Yeah, so technically, I mean, trade secret, we didn't talk about a lot, is really, really broad, right? A trade secret is defined as anything that gives your company value, right? It could be a customer list. It can be a process that's internal to your company. It can be marketing materials. It can be a future plan, right? Those are all trade secrets as long as they're not generally known outside of your company. There's also what I talked to a lot of clients about is called negative know-how, right? It's kind of the opposite of trade secret. It's all the failures that your company went through to get to the point that they're at, right? Those things are incredibly valuable to another company that's taking you over, right? Because otherwise they would have to walk through all those steps, right? So when you sell a company, sometimes if there's limited technically IP, like hard IP, what you do is the owner of the prior company comes on board to the new company for a certain amount of time to sort of brain dump everything that they've got. And they come on for a salary, and the company usually wants that because they can kind of shepherd everything, and then you just transfer everything over that you know, and that is the IP associated with the company. Yeah.
I'm afraid actually we're going to have to call it there.
Okay.
Because actually, Justin's going to be working with our Jumpstart cohort for a period of time now. So I'm afraid I'm going to have to shepherd you on to
Oh, okay.
the learning
Well, great.
path.
Well, again, thank you very, very much. I have.